Mr. Rosen, good morning.
Thank you. Good morning, Chief Justice Marshall and Your Honors. May it please the Court, I'm Neil Rosen. With me is Jenny Cooper. We represent Dr. Mukendi. The two issues on appeal from the trial court were the appropriateness of the grant of Rule 60B, relief from judgment, and the appropriateness of the grant of summary judgment. I'd like to start initially with the issue of 60B-6 relief. In our view, the Court did not abuse its discretion in finding sufficient extraordinary circumstances and an appropriately reasonable period of time for the bringing of the motion in this case. The unique and interesting distinguishing factor of this case is the fact that, and that make the circumstances here genuinely extraordinary, are that Mr. Owens acted as lawyer to Dr. Mukendi and to Dr. Mukendi's companies over a period of approximately 10 years before the lawsuit was brought and after the judgment, the default judgment in the lawsuit was obtained. During that period of years, Mr. Owens had significant conflicts of interest, negotiating a contract with a client, negotiating and entering into other alleged oral agreements with the client over a 5 or 6 year period from 1990 to 96, and then suing. You call
them undisclosed conflicts. What do you mean by that?
Well, what is remarkable here is, A, he had the conflicts, and B, the record is utterly devoid of even a mention that he ever said to Dr. Mukendi at the time of the drafting of the contract, at the time of the filing of the lawsuit, and after, I have a conflict, or even I may have a conflict. I can't represent you. You need separate counsel. Don't talk to me about the lawsuit I've just filed. So, for example, just to go back to 1989, with the contract that they entered into, he says in his affidavit that he thought Dr. Mukendi had a lawyer. That's not enough in this Commonwealth and under our ethical rules. He should make sure that a person that the record will suggest he did represent and had dealings with as a lawyer, he should make sure that that person has counsel.
Why isn't this a matter for, the BBO or whatever, for the various forms of misconduct you allege? By the time we get to the actual litigation, where Mr. Owens is suing Dr. Mukendi, claiming that there's a debt owed on this contract, he's clearly an adverse party, and you are saying there is misconduct of an adverse party. And I don't see why that isn't 60B3. I'm not aware that we have something, well, is it, ordinary levels of misconduct is going to be 60B3, but if it's really bad misconduct, that's going to be 60B6. It seems to be what you're arguing. You're saying this misconduct is sort of worse, therefore I get to kick it over to 60B6.
Well, in many respects, that's precisely what we're arguing. In other words, in the usual 60B3 case, let us say, misconduct of an adverse party, a person in Dr. Mukendi's position has his own lawyer. And the other side's lawyer, as in the Honer case or the Tibbetts case, does something inappropriate. But at least you've got your own lawyer, and at least you can deal with it. Here, you have the adverse party wearing many hats. He's a lawyer to his adversary. He's a lawyer to the companies.
Mr. Owens was certainly not purporting to represent Mr. Mukendi in this litigation. At some point, an appearance is filed by this attorney Rodriguez, moving to postpone the assessment hearing. And, I understand Dr. Mukendi tells us, well, somehow Mr. Rodriguez wasn't authorized to do that. But at least Dr. Mukendi had access to independent counsel by the assessment of damages here.
Well, he had momentary access to independent counsel. He wasn't neglectful in simply ignoring the lawsuit or even ignoring the default. He spoke with Mr. Owens, who, again, we submit, should have said, Dr. Mukendi, don't talk to me about this. You need a lawyer. But he never did. And so even after default judgment and before the assessment of damages hearing, Mr. Owens said, don't worry, you don't need a lawyer. Pay me the $5,000 retainer that you were going to pay to Mr. Rodriguez. And yes, the record suggests.
So you're saying that this makes it extraordinary. But why, yes. Let me ask you this, why isn't it disclosed? Because Dr. Mukendi knew that his own attorney was suing him at one point. So why at that point wouldn't it become a disclosed conflict of interest?
Well, to me, in our Commonwealth and under our ethical rules, you don't visit the niceties and nuances of how lawyers are supposed to behave on clients. And it may be for our purposes, yes, that was clearly a manifested conflict, but this person continues to deal with Dr. Mukendi and his companies over the years, even after the lawsuit is filed. And if he had said the simple words, get yourself a lawyer.
Can I ask,
Don't talk to me.
What is the evidence in the record that Mr. Owens continued to represent Mr. Mukendi or his company after the lawsuit was filed?
Okay, so the lawsuit was filed
July 1998.
In November of 1997.
I'm sorry. And what happened in July 1998?
July 1998 was the
default judgment.
Default
Okay,
judgment and the hearing on assessment of damages. But you have some representation of the companies continuing into 1989 at the record.
1989?
Yes, representing Maminko. I'm sorry, you went afterwards. There are essentially two. In 1998 of June, he writes a letter indicating that he is counsel to Maminko. That is the company of which Dr. Mukendi is principal. That letter is dated, I think, May 21.
Does he send that letter to?
Of 1990 to the U.S. Embassy, trying to get help in dealing with the troubles in the Congo with the diamond mines and getting some sort of reparations in order. He represents himself at that point in time as being the lawyer for Maminko. That is right between the filing
And the judgment.
And the default judgment.
Okay.
And he is acting as his counsel.
In the other instance?
In the other instance, even into 2000, this is well after, but he's working with Dr. Mukendi to write to Brigham and Women's Hospital, where he was employed at the time, to make sure that there wasn't any adverse employment action taken against him. And
So this is in year 2000, and that's in the record as well?
that's in the record as well, at Appendix A345.
Could you?
Now, I can see that these are, they're, I don't want to call them one-offs, because this was an enduring relationship.
Right, I
but
understand
there was
that.
never a disengagement. Lawyers are supposed to make it clear to clients.
Could I ask you, the appeals court opinion places, I think, some fairly significant emphasis on this letter in February of 1999, where Mr. Owens indicated in certainly fairly strong and unambiguous wording that he did intend to pursue this debt. As I read the appeals court's opinion, they were willing to give Dr. Mukendi the benefit of the doubt based on all the points you have raised, but did seem to say, look, after February 99, there can't be any of this mistaken belief, oh, this is just a formality, he's not really pursuing it. There's this letter. What's wrong with that part of the appeals court's analysis?
What's wrong with that analysis, in my view, is that it pays insufficient attention to the serious ethical obligations that lawyers have in this Commonwealth. This wasn't the first time that Mr. Owens, or counsel for Mr. Owens, in this case, who wrote the 99 letter, but was his own law partner, wrote nasty letters. He threatened criminal charges in 1994, going to the INS. In this case, he threatened to get New York lawyers. None of those things ever happened. And as I mentioned just a moment ago, in response to Justice Cordy's question, he continued to represent Dr. Mukendi.
Well, whether he represented him or not, did he ever, after the February 99 letter, does the record indicate that Mr. Owens had any communication with Dr. Mukendi to the effect of, oh, I just had to send you that letter, ignore it, I don't really mean it?
None that I'm aware of, but the record is also clear that he never said, you need a lawyer, Dr. Mukendi. This has gone too far. He should have told him at the time he filed the lawsuit.
I take it, Mr. Rosen, our jurisprudence under 60b-6 is that, in a sense, you can't fit within one of the others. The appeals court says, no, this was an adverse party. What you are saying is, one hat is he's an adverse party. What makes this very different is the nature of the fiduciary relationship between the attorney and the client, where the attorney is not just the adverse party, but is in considerable, continuing, ongoing breach of the, but in addition to the breach of the ethical rules, is breaching his fiduciary obligation, and therefore it was appropriate for the Superior Court judge to look at those factors and to take that into account and to exercise, in other words, purely a 12B3, a 60B3, I'm sorry, a 60B3, the judge in the Superior Court doesn't have any discretion.
It's 1 year or nothing.
It's 1 year or nothing, and
Yes.
he or she doesn't have the power to extend that. The question is here is, was there sufficient other to give rise to the 60B6 category, correct?
Yes, that is precisely the analysis. You could call it a 60B3 plus or 60B1 plus.
So this is
It's
not a
additional
claim, for
conduct.
example, which one might have, where there's misconduct by the adverse party. Misconduct by the adverse party in the 60B3 sense might be, for example, having an expert's report that isn't disclosed upon order of the court, refusing to hand over discovery, notwithstanding that there's a court order to do so, and that subsequently emerges, that might have had an impact on a jury. I mean, that's the kind of misconduct by an adverse party. In other words, it is, as it were, the adverse party in connection with the factual and legal disputes of the case itself. That's not what's at issue here. It is the role that the adverse party has with respect to this client, correct?
That is correct, and that's what distinguishes cases like Honer and like Tibbetts. And there is a whole line of authority in this Commonwealth for this concept. You've got the McIntyre case. It's the appellate division where the other side's lawyer's refusal to arbitrate after he had extracted a judgment based on that promise could have been misconduct of counsel. But the court found it an overriding circumstance that this was simply dishonorable conduct. This court decided in 1981 in the Chavour case, this is just an example, but a clear 60B1 violation. Court's mistake, didn't send out a notice. But this court found that went so to it was such a fundamental flaw in the integrity of our system of justice that it ought to be B6, not B1. In the Winthrop case, that's an appellate court case here, 1990, their opposing counsel failed to disclose a contingent fee agreement in the context of a litigation. Yes, misconduct of an adverse party under B3, but the court found justice wasn't done here. Now, in the Perel case, this court, 1983, you had a situation where the insurer wasn't subrogated, didn't have its client's authority to settle. Yes, I suppose that's misconduct, but it's also a fundamental flaw in the system. And the one case we do have, it's in federal court. Magistrate Judge Swartwood, 1997, the Martirosian case, conflict of interest on the part of a person's attorney. Yes, in that very matter, the police chief was represented by a lawyer who also represented the town and didn't get a fair defense. And the court had little hesitation deciding that was a 60B6 issue. Now, the appeals court, I would just point out two things. The appeals court says a couple of things, and this is where I think it got it wrong. In its opinion, it's in justifying this, in trying to cabin it within B3, it says he, meaning Dr. Mukendi, relied on advice received from the plaintiff not to answer the complaint or mount any defense, saying clearly that's misconduct of an adverse party. And I think that simply is too literal a reading of what happened here. The real wrong was that he failed to reveal he had a conflict of interest.
Well,
he failed to tell Dr.
essentially,
Mukendi to get a lawyer.
Essentially, the argument that your client is making is that the explanation for the default judgment doesn't go to the adverse party. In other words, this is not an adverse party saying, if you pay me, I'll withhold a default. It's the lawyer. He's got two
you can
heads.
separate Mr. Owens into two entities. He's an adverse party represented by Mr. Murray of his own law firm. He's also Dr. Mukendi's lawyer and his company's lawyer on various matters. And that, to me, results in conduct fairly viewed that's even more egregious than what happened in the Martirosian case.
Before you run out of time, could you move on to the summary judgment issue?
Yes. In brief, on summary judgment, I would say the following. The Court made no errors of law in viewing the contract, the written contract, as unambiguous. No obligation to pay a personal loan of $200,000.
Why is that the way it's written, that isn't in the nature of a personal guarantee?
Yes, it was not in the nature of a personal guarantee. Nothing in the written contract about a personal guarantee. It simply says that for $200,000, Mr. Owens gets a 35% stake
But
in the company.
Dr. Mukendi signs it as a party. The contract says the parties agree, and Dr. Mukendi is a party. It doesn't say the corporation agrees.
Well, the corporations are signatories as well.
Yes, but
And-
so
and
is
the
Dr.
contracts can do many
Mukendi.
things. They can provide for a purchase of an equity interest in a company. They can provide for a loan if that's also going to be involved. But there was no repayment obligation connected to that whatsoever. And likewise, the $100,000 claim, yes, that was the sole obligation to repay along with, I shouldn't say
And
sole, along with the travel
wouldn't the
expense.
plaintiff want Dr. Mukendi personally liable?
He would, but he was an experienced attorney. And not knowing that Dr. Mukendi was unrepresented or thinking he had another lawyer but never dealing with that other lawyer, he should have said, here's a provision that says you, Dr. Mukendi, personally guarantee this 200, I don't even know what it would be a guarantee of. I guess a guarantee that the company will in fact issue these shares, and if they don't, I get my $200,000.
Isn't there at least some ambiguity that it could be viewed as a personal liability?
With all due respect, I see none
Well,
whatsoever
at least
in the contract.
if it's ambiguous, you don't get summary judgment.
That's correct.
What
If it
the-
is
what
ambiguous,
the
but I see
severe-
no ambiguity, and I don't think the court saw any ambiguity either. The court seemed to look at it as maybe this is a series of loans that have nothing to do with this contract.
As
Oral
this-
representations, promises to pay, but all of those were time barred, and they certainly weren't subject to a 20-year statute that was in the written contract, the argument on which was not even made before the trial court.
Thank you, Mr. Rosen. Mr. Barter?
Good morning. I'm John Barter. I'm here for Mr. Henry Owens today. If I may, I'd like to address some of the issues that were raised by some of the justices in the course of Mr. Rosen's argument. Justice Sossman and Justice Cordy were interested in the argument or the issues raised in the appeals court with regard to the strongly worded letter from Mr. Owens' attorney indicating to Mr. Mukendi, essentially, we're not fooling around here anymore, I intend to collect this debt. And that letter was in 1999. Mr. Rosen suggested and directly told Justice Cordy that there was a letter in the year 2000 in which Mr. Owens was representing Mr. Mukendi, Dr. Mukendi. It's not so. I'd ask you to look at the record and to look at the record with regard to that letter. That letter is on page 345 of the record appendix. In that letter, Henry Owens writes to the Brigham and Women's Hospital with regard to certain problems Dr. Mukendi was having at the Brigham and Women's Hospital. And in that letter, he directly says, I write to you regarding my investment and ownership in Miminko. It appears that Dr. Mukendi was selling interests in Miminko to doctors on staff, or there was some representation that Brigham and Women was somehow involved with regard to those companies, and certain problems arose as a result of that. Mr. Owens writes saying he's writing about his own investment, his own interest with regard to essentially getting paid. The second paragraph of the letter says, unfortunately, a large sum of money is owed to me at this time, and I have a judgment against Dr. Mukendi. So Mr. Owens isn't writing as counsel for Mr. Mukendi. He's writing as someone who wants to get his money back. I have a judgment. This is an ongoing dispute we understand the doctor is having with the hospital, but I hope that you will cooperate and allow this matter to move forward. He doesn't say I'm the attorney, never does.
When the original complaint was filed and Mukendi didn't answer it, what does the record show about Mr. Owens' conduct or statements at that point?
The record, if I may, Your Honor, the record, as far as the record in court, simply shows that no answer was filed until the default judgment was entered and ultimately Mr. Rodriguez appeared.
Well, that's what I thought, because the appeals court doesn't talk about anything occurring then other than a default was entered.
Right. As far as strictly following the docket sheet, a default was entered.
Was
and,
there
and
evidence
a default
that-
judgment entered.
Was there evidence?
Right, but what gets filed later when the motion to vacate the judgment comes in? Surely then there's this explanation, here's why.
Yes, correct. It's only more than 3 years later when there's a rear guard action asserting all manner of misconduct on the part of Mr. Owens. The record, Justice Greene, with regard to the Rule 60B, shows there's an affidavit from Dr. Mukendi saying that I was tricked by Mr. Owens and he told me not to file an answer. And Mr. Owens files an affidavit saying, not so. I spoke to Dr. Mukendi and he told me, listen, Henry, I know I owe you the money. I'm not going to defend it.
Yeah, but did Mr. Owens say to Dr. Mukendi, I can't advise you with respect to this. Go and retain a lawyer and have that lawyer negotiate with me?
The record does not show that there was a discussion along those lines. However, the record does show that Dr. Mukendi was represented by another law firm, a respectable law firm, Choate Hall & Stewart. And the record shows that Choate Hall & Stewart was preparing loan documents and filing various things in various agencies on behalf of Dr. Mukendi during the relevant time period. You could look to the record appendix at 204 through 209 to see some of those interactions where Dr. Mukendi was working with Choate Hall & Stewart. And what Henry Owens says in his affidavit is, it was my understanding that he was represented by Choate Hall & Stewart. When the loan document was prepared, he said, could you send it to me in advance? I'd like to have my lawyers look at it. He sent it to him in advance, and then he met with him, and the document was signed. This is the way that Mr. Owens describes how matters unfolded. We don't have a precise description saying, I advised him that there was a potential conflict of interest and that he should have counsel. He thought he had counsel.
By the way, that there was never any evidentiary hearing to resolve these sort of diametrically opposed versions of who said what when.
That's correct. Okay. And with that in mind, I'd suggest that the evaluation of this 700-page record, the record appendix that we have here, could be done as well by the appeals court as by the trial court in this matter.
Could I also ask you, to clarify, what was it that this Attorney Rodriguez did with regard to the assessment hearing appearance, filing a motion, or what? There's some ambiguity here between the two briefs as to just what was the role of Attorney Rodriguez?
Your Honor, Attorney Rodriguez appeared at a couple of points on the docket sheet and in the litigation. A notice was sent to Dr. Mukendi in June saying there's going to be a hearing in July 15th. The notice was sent on June 16th telling him there's going to be a hearing on an assessment of damages. So on the date of that hearing of assessment of damages, Mr. Rodriguez appeared with his notice of appearance, which is in the record, and his motion to delay the assessment of damages hearing. The record shows that he appeared before the court, made his argument as to why the hearing ought to be delayed, and that his motion to delay the hearing was denied. So at that point, he didn't file a notice of appeal from that order, nor when the judgment issued the next day did he file a notice of appeal.
Did he do anything, make any argument at the assessment of damages hearing itself?
We have not any transcripts of the assessment of damages hearing, and all we have is his motion, which is in the record, in which he says, I've recently been retained. I'd like to have the opportunity to review the record in order to prepare for an assessment of damages hearing and to address whatever issues there may be here. But the next time that we see Mr. Rodriguez appear, interestingly, is his name does turn up in a pleading that was filed with regard to the hearing over in the Brookline District Court where the supplementary process was going on, where they were trying to collect the money on the debt. So what we see is the continuity whereby he was representing Dr. Mukendi at the end of the Superior Court case, and then when it came time for the collection to begin, his name turns up on the pleadings there.
Can I just ask you one question, Mr. Barger? And I'm looking at, I think it's your brief. To retain, I was required to pay a retainer. Dr. Mukendi states that Mr. Owens convinced him not to file an answer in the case, but to give the $5,000 to Mr. Owens and said that's why he didn't answer the lawsuit. Is this in the nature of testimony, an affidavit?
This is in the nature of Dr. Mukendi's affidavit, which Mr. Owens denies. Mr. Owens denies in his affidavit repeatedly that I ever lulled this man into not filing an answer, or advised him that he shouldn't file an answer, or advised him that I was never going to seek to collect on the judgment.
Doesn't a fact finder have to resolve this dispute between these affidavits before we can decide where this motion to remove the default falls?
From my perspective, that would be one way that this court could go. I think that we do have a record.
Wouldn't that be the proper way?
I'm not
sure. Here you got a client, and the lawyer is investing in his diamond mines and all this stuff and loaning him money, and then this lawsuit is brought, and the client says, "Well, my lawyer told me don't even answer this. Don't worry about this." Well, the lawyer says, your client says, "No, I never said that."
But you don't dispute that your client never said, go out and get another lawyer to help you while we're negotiating this contract.
I don't dispute that he didn't say go get another lawyer, but what I affirmatively say to this court, which Mr. Owens said to the trial court in his affidavit, was, I understood that he had a lawyer. We sent the documents so that his lawyer, presumably Choate Holland Stewart, could review this, and it was his understanding that they were in the mix.
Okay, did you argue to the Superior Court judge that this motion should be treated as a 60B3 motion?
I wasn't at the Superior Court level.
Was that argument made?
But the record shows that the Superior Court judge was aware from the Superior Court judge's decision, where the judge says, I can't grant relief here under 60B6 unless the threshold is met with regard to 1 through 5.
Yeah, but
so
it's true that what he submitted, what was submitted on his behalf to the Superior Court, only raised 60B1. It seems to me, if what you're saying, if what a Superior Court judge is being told is, Judge, you can't grant relief under 60B6 because this fits under 60B1. And the fact that the judge acknowledges the general legal and correct legal principle, if something fits under one of the others, it can't be 60B6. Still, hasn't there been sort of a waiver to say, I've based my argument on 60B1, that's where this fits, and that's why you can't put into 60B6. But if you didn't, raise, the alternative of, by the way, I think it would also fit under 60B3, why isn't that waived?
Well, I'd suggest that the record clearly shows what was in the mix here. We have several hundred pages of briefs where rules 60B1 through 60B6 are all mentioned. In fact, Dr. Mukendi himself.
And isn't that exactly the reason why you have to make the argument to the judge? Because if you've got hundreds of pages where you just mention all parts of the rule, you have to direct the judge's attention so he or she knows what your argument is.
Yeah, and say,
and it's not just unfocused on hundreds of pages.
And say that the defendant's motion fits under 1, or it fits under 2, or it fits under 4. I mean, it seems to be not enough to just sort of generally go, here's what the, what 1 through 5 are.
If I may.
But an argument, here's the one that covers this fact situation, therefore you can't go to 60B6. That argument was clearly made as to 60B1. It doesn't seem that it was clearly made as to 60B3.
I'd suggest that the role of the trial court judge is to make a correct ruling based upon the law, the governing law. And here the governing law was discussed
on the arguments presented to her.
May have been a very conscientious judge who studiously reviewed each of the other subsections, but I'm not sure that the judge's conscientiousness in doing so relieves your client of normal waiver principle.
Well, my position is that that Dr. Mukendi here argued only 60B6, and Mr. Owens argued.
Therefore, he had to establish.
And
that none of the other provisions, 1 through 5,
exactly. It's the burden of the moving party to show that they meet the threshold. And this is based on the decisions of this Court, that there's a threshold showing that must be found by the moving party. And that threshold showing is that 1 through 5 don't apply. And
May I ask you another question, because I see your time is running down. Let's assume we conclude that 60B6 was an appropriate category on which the judge could vacate the judgment here, or vacate the default judgment. What's your best argument as to why it was unreasonable for her to allow this to have occurred 3.5 years or so after the default judgment?
The best argument is, if we look to the rule itself, it says that the motion must be filed within a reasonable time.
Right.
Is reasonable time a year? Well, with regard to 1 through 5, yes. Reasonable time, the outside limit is a year. A judge could say that 2 months is not a reasonable time. So the outside limit is a year.
Yeah.
And what we have here is someone who waited 3 years after the judgment, 3 years after they had independent counsel. And a point that I haven't raised here, but that the appeals court mentioned, is that Dr. Mukendi filed 3 financial statements in the probate and family court.
I was going to come to that. Didn't he admit the debt in those financial statements?
Yes, he did. And in
So
those,
what he's trying to do on the surface of it is get his support payments reduced in the divorce trial, correct?
that would be
By
my
saying, I owe
inference, Your
Henry
Honor.
Owens $500,000, and now he's coming over to the Superior Court and saying, oh, by the way, give me another shot at litigating this $500,000. Aren't those judicial admissions, those financial statements?
I would suggest that they are. And not only do they show that he knew about the judgment, and if I could point out the dates, this is to direct my response also to Justice Cordy, December 20th, 1999, with different counsel. He's not someone who can't have counsel. He had his own counsel in the probate court proceedings. He filed a document under oath saying, I owe Mr. Owens $450,000 as a result of a judgment that was entered against me personally.
And that's true. And he would have been committing a fraud on the court if he had neglected to mention that.
If he had failed to disclose that. Then
it doesn't mean he – go ahead, I'm sorry. It doesn't mean he admits that there's no basis on which to vacate that judgment.
No,
I'm sorry.
but it shows and is relevant to Your Honor's inquiry about what's a reasonable time. So he knew about the debt, he had separate counsel, and he's saying under oath, I owe this money in 1999. He still waits 3 years. He got new counsel a year later in the family court in October of 2000, said the same thing, said, I owe this money. And he still doesn't file until a couple of years later. Then finally, in April of 2001, he acknowledges that he owes the debt with counsel and doesn't do anything about it.
This is not an unsophisticated person.
Not at all. And I'd suggest, I know my time is up, but the record shows that after this transaction and before this transaction, he was engaged in a set of loan deals, international deals. He was claiming to be in control of $2 billion worth of diamond reserves. He's filing financial statements. He's filing limited liability corporation documents. He's borrowing money from people all over the place and giving very strange loan documents to them with various strange individually tailored provisions. And the record shows that this is happening long after Mr. Owens is out of the picture. And what we have here, unfortunately, is a rearguard action by Dr. Mukendi to say, Mr. Owens is responsible for all of my problems.
Thank you, Mr. Barter. Just, Mr. Barter and Mr. Lozen, although you did mention it in your brief, Mr. Barter, I confess I didn't pick up the 3 words, Choate Hall and Stewart. I was an equity partner in Choate Hall and Stewart. I resigned from that position, I think, in 1992. However, I would ask both of you to consult with your respective clients to ascertain perfectly openly whether they would like me to be recused from this case. I am routinely recused when there's an issue involving Choate Hall and Stewart.
Thank you very much, Your Honor.
Thank you.